All right, let's get right into it. Today, we're unpacking a really critical part of the European Union's new AI Act, specifically how high-risk artificial intelligence gets tested in the real world. This analysis is based on the fantastic commentary by Professor Vihar Kiskinov, Doctor of Legal Science, on Article 60 of the Act.
So let's start with the big question, the one that regulators really had to grapple with. Before you release a powerful new AI system out into the wild, how can you be absolutely sure it's safe, that it's fair, that it's reliable? How do you find those unexpected problems without anyone getting hurt? This is the core challenge that Article 60 was designed to solve.
First things first, we need to be clear about what we're talking about here. You see, the EU AI Act is smart. It doesn't treat all AI the same. It zooms in on what it calls high-risk systems. These are the AIs where a mistake could have really serious consequences. Think about an AI that helps doctors with diagnoses, or one that sifts through job applications, or even one that helps manage our power grid. These are the systems that demand the highest level of scrutiny. And honestly, this is the perfect analogy for what's happening. Before a new driver gets to be on the road by themselves, they have to pass a supervised test, right? They have to prove they can handle real-world situations safely. Well, Article 60 applies that exact same logic to high-risk AI. It's basically a mandatory, controlled test drive, with regulators watching closely before that AI gets its license to be sold or used in the market.
So, to really understand how this all works, we're going to walk through these 5 key stages. We'll start with why this test is even necessary. Then, we'll look at the approving process, the importance of transparency, your rights as a participant, and finally, the safety net for when things might go wrong. So, let's jump into our first section. Why do we even need this safety check in the first place? Well, the thinking behind this structured testing is actually pretty layered. On one level, sure, it's about creating a single, predictable market for AI across the entire EU. But really, the much bigger deal is about building trust. By letting developers find and fix risks before a big public launch, the whole process is designed to protect our fundamental rights and our safety. And it fills a huge gap for these powerful, new standalone AI systems that weren't really covered by older product safety laws.
Okay, so you're a developer with a high-risk AI. How do you get permission to even start this test drive?
It's a very formal 2-step process, and it's all about ensuring safety right from the beginning. First, the AI provider has to map everything out in a super detailed blueprint. And I don't mean a quick outline. This is a comprehensive plan that has to cover every potential risk, every safeguard put in place to protect people, and exactly how all the data is going to be handled. Then, that whole plan gets sent off to a national watchdog for a thorough review.
And this introduces the key gatekeeper in this whole process. In each EU country, there's a Market Surveillance Authority, or MSA. Going back to our analogy, the MSA is like the examiner in the driving test. They're the ones who review the plan, they assess all the risks, and they have the final say. They can approve it, reject it, or send it back with changes to make sure the test is as safe as it can possibly be. Now here's where it gets interesting. The Act strikes this really clever balance. To keep things moving and not stifle innovation, there's a default rule called tacit approval. Basically, if the MSA doesn't say anything or object within 30 days, the plan is automatically considered good to go. But, and this is a big but, the Act also respects national laws. If a country's own laws demand a formal, explicit yes for this kind of thing, then that national law overrides the 30-day default rule. Okay, so once a test gets approved, it doesn't just happen in the shadows. A core principle of the entire AI Act is transparency. So how do you guarantee accountability? Simple. You create a public record. Every single approved test gets logged in a central EU database, and each one gets a unique ID. This means regulators, and in many cases the public, can see exactly what AI is being tested, where it's being tested, and for what purpose. It's transparency baked right into the system. But the system is also smart about it. While transparency is the default, the Act understands that some systems are just too sensitive for a completely public record. For AI used in really sensitive areas, think law enforcement or migration or critical border control, the test is still registered, but in a separate, secure, non-public database. So, a new AI for scheduling hospital appointments, public database. An AI for coordinating border patrols, that goes in the secure one. All of this brings us to what is, without a doubt, the most important part of this whole framework, protecting the rights of the human beings involved in these tests. This quote, taken directly from the Act itself, establishes a right for every participant that is just incredibly powerful. It puts the individual in complete control.
It means you can walk away from the test at any moment, for any reason at all, or for no reason, without having to explain yourself and with zero negative consequences. These rights create what you could call a human shield around every participant. Before a test can even start, you have to give your informed consent, which means you have to fully understand the risks and agree to be a part of it. As we just saw, you can take back that consent anytime and demand that your personal data be completely wiped. And crucially, there always has to be a human in the loop who can override whatever the AI decides. On top of all that, the law demands extra protections for vulnerable people, like kids or individuals with disabilities.
Okay, but what happens if, despite all of these rules and precautions, something goes seriously wrong during one of these tests?
The law is incredibly specific about this. It doesn't leave the word serious open to interpretation. We're not talking about a small bug here. A serious incident is defined as a major failure that either causes or has the potential to cause severe harm to people, to our critical infrastructure, or to our fundamental rights. And when that happens, this timeline shows the rapid response protocol that is absolutely mandatory. The second a serious incident is identified, the provider has to act immediately to contain the damage. They've got to report it to the MSA, and if the problem can't be fixed right then and there, they are legally required to suspend or even completely terminate the test. They also have to have a recall plan ready to go to pull the system out of the testing environment entirely.
And Article 60, Paragraph 9 makes one final thing crystal clear. The company testing the AI is on the hook. They are legally and financially responsible for any damage it causes. Period. Following the rules doesn't get them off the hook if something goes wrong. This gives providers the strongest possible reason to make their tests as safe as humanly possible.
So when you step back and look at this entire framework, the required plans, the regulatory oversight, the public registers, and these powerful safety nets, it leaves us with a really big question. The EU has a history of setting global trends in regulation. So is this careful, cautious, human-first approach to testing powerful AI going to be the blueprint that other countries around the world adopt to balance the incredible promise of innovation with the absolute necessity of public safety?